SJC-13145 in the matter of Michael James Kelley.
And Attorney Harbison.
Thank you. Pamela Harbison on behalf of Bar Council. May it please the court. This case involves an appeal by Bar Council regarding the Board of Bar Overseers' erroneous decision that when prosecuting a case involving a breach of attorney-client confidentiality, Bar Council has the burden of proving not only that certain information was confidential under the Rule 1.6 of the Rules of Professional Conduct, but also that the information was, quote, not generally known, end quote, within the applicable local community or trade at the time the disclosure was made. During my presentation, I would like to make 4 points.
If I could just ask you to tell us what, in your estimation, is the difference between confidential information, which you agree you have the burden of proof on, and information that is not generally well known.
Well, I think Your Honor makes an important distinction just in your question, which is generally known versus generally well known. And that is a standard that I believe that the ABA has proposed to be widespread notoriety being the proper standard for generally known. But I believe the difference is, as you read the rule and the comment 3A to the rule, the board has previously found that comment 3A defines confidential information as information that is gained or during or relating to the representation of a client, whatever its source, that is protected by the attorney-client privilege, is likely to be embarrassing or detrimental to the client if disclosed, or information that the lawyer has agreed to keep confidential. I believe that those 3 things in and of themselves are what constitute confidential information. Whether or not information has become or is generally known within the applicable local community or trade is an exception to that rule. And that's what the board stated in the matter of Smith when it said that the comment 3A first defines confidential information as those 3 things that I just mentioned, and then further explains that generally known information is not ordinarily included in the confidential information definition, implying, of course, that sometimes it is and sometimes it isn't. This is not part of the definition, as the board now argues, but rather a further explanation of certain contexts in which otherwise confidential information may no longer be confidential under the rules. During my presentation, I would like to make 4 points. The first is that the initial burden of proof, of course, lies with the Bar Council to prove that information is confidential within the definition of Rule 1.6. And in this case, Bar Council satisfied that burden. 2, whether information is generally known within the local community or trade must be treated as an affirmative defense that the respondent must prove, and here the respondent failed to do so. 3, Bar Council's interpretation and application of the rule protects clients, and the reading and standard proposed by the board is untenable and does not offer the same level of protection that Bar Council's reading does.
Counsel, can I interrupt you? I know you're going through your list here.
Sure. Of course.
So I understand what you're saying, but if we could just look into the facts in this case, and I think that something that Bar Council says resonates with me about this notion that to the extent that the attorney knows that what's been disclosed to him is confidential within the rule, but leaving aside whether it's attorney-client privileged or what have you, was something disclosed to the attorney in confidence while they were within their relationship. And in this case, there's no dispute that this stuff was confidential. Bar Council says, though, before you're going to disclose that, you as the attorney that has that ethical obligation you've got to satisfy yourself that this meets within the exception before you do what you did. And in this case, that's particularly important because it was a gratuitous filing that had nothing to do with this lawyer whatsoever, that he just seemed to me from the record, just got notice of it through Pacer or whatever electronic filing system, because at some point his notice of appearance was in there.
Correct.
And he takes it upon himself a couple of years later to file this thing. Why is that unreasonable and, as you, to use your words, untenable for him to have to affirmatively lay out in the defense why that meets the exception to the rule? He's the one that decides to do it. He sat there in his office and said, I'm going to write this thing and I'm going to file it. Why is that untenable then to say, you're raising this, you've already done it before there's been any disciplinary process whatsoever? Why shouldn't that burden be on the lawyer to show that he's within the exception as an affirmative defense? I don't understand why you say that that's untenable.
No, I believe that you've actually stated perfectly Bar Counsel's formulation of the rule. It is on the respondent, on the attorney, to prove, to take on the burden of showing that the reason that he disclosed this information, which was otherwise confidential, was in fact within some exception of the rule. That's exactly what Bar Counsel is advocating for. What I am stating is untenable is the board's test that states on page 38 of its brief that Bar Counsel must show that information is not available through generally available sources. I believe that that is a completely untenable standard because, as we all know, Google and other search platforms are everywhere. And if you dig deep enough, you can always find something out about somebody.
Ms. Harbison, I know you haven't gotten to point 4, and I'm anxious for you to get to point 4, so I'll be brief. Whoever has the burden of proof, we have to sort of get at who's generally known. And you just point out all these platforms that we have right now. But if a lawyer can just hit Google or pick up the newspaper and gather this information, that's different than somebody who has inside information and can, in a very sophisticated way, through a search engine, put something into YouTube and come up with something that's really inappropriate to disclose about a client. So whoever we end up having have the burden of proof, we still have to be able to get our arms around what's generally known. And that last statement that you made is, with all these platforms, anyone can figure it out. I'm not so sure that's true.
Okay,
And that should be the standard.
So I believe that actually goes directly to point 4, which is
Good.
What is the standard of what is generally known? And Bar Counsel is urging this court to adopt the ABA standard that something has to have achieved widespread notoriety in order to be generally known. So in this particular case, there is no evidence before the hearing committee or the board whatsoever with how this respondent obtain this information regarding his client. He might have gotten it from Google. He might have gotten it from his friend who works at the police department. Who knows, right? Because he did not present any evidence, because the burden was on him to show the hearing committee how he obtained the information. Now, with respect to the Google question, it can't possibly be that someone with a very distinctive name, like let's say Dzhokhar Tsarnaev, would have somehow less protection than someone with a very common name like Robert Brennan. If you Google Robert Brennan, which is the client in this case, you will find many, many, many Robert Brennans, most of whom are Catholic bishops or stock penny brokers and have nothing whatsoever to do with this particular client. However, if you Google Dzhokhar Tsarnaev, you're going to come up pretty much with one guy, right? So there cannot be a standard that says if it's easily found on Google, then that's the standard. If that makes it okay to disclose whatever you want that you find on the internet about that person. It has to be something more analytical and more professional. There's an expectation of professionalism.
But then we can't retain generally known. Generally known doesn't work with that argument. I understand your argument. It's a good one. But we'd have to get rid of generally known. If you can sit there in 2 seconds and Google something, arguably it's generally known.
Well, I think it does depend on the, for example, when you Google something, you can get pages and pages and pages of hits, right? So if you get something, if I Google stimulus payment, Joe Tsarnaev, I'm going to get #1 hit that he received a $1,400 stimulus check. That's not confidential information. It may be embarrassing to the client, but in this case, if the attorney for Joe Tsarnaev disclosed that, he could successfully prove by showing his Google search that the information had widespread notoriety because it appeared on many different media platforms and was easily accessible. If I Google Joe Smith of Boston, I'm going to get pages and pages and pages of returns of results. And so it is up to the attorney in our formulation to show that the information was not buried somewhere deep in the internet and therefore was generally known. And I think that generally known, if we equate that to widespread notoriety as the ABA does, then it does work. That I think that it is a workable definition. And that is exactly what the ABA has put forth in its formal opinion 479. I would like to also point out that okay, so let me go back to my argument that whether generally known within the local community or trade must be treated as an affirmative defense, because I believe there are two main issues before this court. The first is who has the burden, and the second is what is the standard, right? So the first being who has the burden. I believe that this court has previously, in very similar cases to this, had, quote, no problem, end quote, shifting the burden to the respondent to explain and produce the information that may exonerate him or her with respect to what otherwise appears to be a violation. And that is from the Murray case. And in that case, it had to do with an attorney who received cash. But here, I believe the same analysis can be applied to this respondent, that he is the one who should have made this analysis at the time that he obtained the information. What was his Google search? What terms did he have to put in? How many pages did he have to go to? What was the information he had to put into Google in order to find these? Because if I Google it, I can't find it. So there has to be some proof by the respondent that the information falls within the exception. And that's how the court viewed the situation with cash in the Murray case, and also in connection with an attorney who impugned the integrity of a judge in the matter of Wilson. And in that case, the court said that the respondent in that case misallocated the burden of proof in denying that his conduct violated the rule 8.2. It is the attorney who must have a reasonable factual basis for his or her allegations of judicial bias before they are made to judge.
Perfect consistency here with burdens of proof and burdens of production, but
I'm sorry?
We don't have perfect consistency in the case law, as you both pointed out well. But when we usually look at a cause of action, for instance, and we look at the party with the burden of proof, here confidentiality, we say, okay, that party has to prove that element. And that's just the normal course of things. It seems a little bit different than the normal course of things.
I don't think it is all that different if you view the comment and the definition of the rule to be the confidential information consists of these three different things. And that is what the burden of proof falls to bar counsel to prove. And then whether or not there is an exception to that, such as generally known, was in defense of the lawyer's integrity or reputation or some other cause of action that was asserted against the lawyer, those are those kinds of exceptions that then the burden shifts to the respondent to prove. And then with respect, again, I see my time is running out. I would just like to reiterate that I would urge this court to adopt the widespread notoriety standard that is set forth in the ABA opinion 479 as what generally known means within the context of our technological age.
Any other questions? Great. Attorney Berman.
Thank you, Madam Chief Justice, and may it please the court, Joe Berman for the board. For 3 reasons, the board maintains that the burden should rest with bar counsel to prove by a preponderance of the evidence that information relating to the representation of a client is not generally known and therefore confidential. Those 3 reasons are the language and structure of the relevant rules. The second reason is the case law of this court regarding the burden of proof and affirmative defenses. And the third reason is that of public policy. Addressing the first reason, there's no disagreement in this case, I believe, that bar counsel, like a prosecutor or a civil plaintiff, bears the burden of proving each element of his case. And the burden, of course, on bar counsel is proving each element by a preponderance of the evidence. As it pertains to rules 1.6 and 1.9, one of the elements under our rules is proving that information was, quote, confidential, close quote. As we discuss in our brief, there's obviously a significant difference between the Massachusetts rules of professional conduct and those of the ABA model rules, which do not use the word confidential. It's right there in the text of rules 1.6 and 1.9, that key word. But that word is not self-evident. Thus, the comments explain that there are 3 types of information that are confidential, as bar counsel has pointed out and acknowledged. That information that is protected by the attorney-client privilege, information that may be detrimental or embarrassing to the client, or information that the lawyer agrees to keep confidential. Bar counsel does not appear to contest that they would have the burden of proving that the information falls into one of those categories, which again are listed in the same comment 3A, as the generally known explanation. The comments immediately thereafter describe situations where information is not confidential, such as this one, where the question is whether the information was generally known. The question for the court is whether the fortuitous placement of the explanation in a comment to the rule converts the definition from an element of the case in chief into an affirmative defense. The answer to that question, the board maintains, is logical and obvious. Its placement in the comment is immaterial. Since bar counsel must prove that information was confidential, its proof must accord with the comments. The key difference, as I said, between the Massachusetts rule and the ABA model rules is the fact that our rules prohibit the disclosure of confidential information relating to the representation of a client, where the model rules are refer more generally to information, that is all information relating to the client. The ABA prohibition is broader than Massachusetts. And because of the limiting language in our rule, it makes sense that the Massachusetts rule must provide a definition of the term confidential, which it does in the comment. It also makes no difference that the relevant part of the definition is phrased in the negative, and this seems to be something that bar counsel really latches onto. The text of the rule and the text of the comment go hand in hand. The latter defines the former. So the fact that within the same comment, within a few sentences of each other, the comment says information is confidential if it's detrimental or embarrassing to the client, or is protected by the attorney-client privilege, but it's not information that is generally known, that makes no difference, a material difference from a legal standpoint. The bar counsel still must bear the burden of proof to satisfy the definition, that it's that fundamental part of its burden of proof. The fact that these appear in a comment as opposed to the text of the rule makes no difference, as the scope of the rules maintain, while the comments don't add obligations to a lawyer under the scope, which is part of the preamble to the rules of professional conduct. This court has advised that the comments provide guidance And the comments, like the rules themselves, are enacted by this court. They have the force of law. Now, I want to contrast what Bar Counsel maintains is an exception for generally known with real exceptions that this court and the board have previously and repeatedly acknowledged are exceptions to the rule. For example, within Rule 1.6, there are exceptions for which the respondent would bear the burden of proof. These are clearly set forth in the text of Rule 1.6a, beginning with the word unless. And so if you look at Rule 1.6a, the reading of the rule says that the lawyer must maintain the confidentiality of information unless the information, and then it starts listing various exceptions, including implied consent, and the exceptions listed in Rule 1.6b. None of those exceptions are generally known, which again is in the comment. So I think just structurally, I just want to repeat that there's nothing within the language or the structure of the rule which would put the burden of proof on the respondent.
Mr. Berman, your next area of discussion is the case law. So what about Murray with the cash and what about that issue and the issue with Wilson as well? With the contempt?
So those are Murray involved cash, Wilson involved a lawyer, Wilson and Cobb both involved lawyers who made disparaging remarks about judges. Both of those situations are judicially created affirmative defenses or exceptions to the rules, which are not within the actual text of the rule. In Murray, and we go into this in some depth in our brief, so I don't want to waste time reiterating what we already said, but in Murray, excuse me, the court set forth a very specific standard regarding a lawyer who receives cash from a client and fails to account for it. And excuse me, the court held in Murray that in that very specific and unique situation, the burden of proof is on the respondent to prove what he or she did with the money. And this is because the lawyer is in the best position to know what they did with the money. The rules are very clear as to how a lawyer is supposed to account for money, including cash, and the lawyer who doesn't account for it has clearly run afoul of those rules. And so I think I would argue that the structure of Rule 1.15, which is what Murray falls under, is very unique and is very different than this case. Under Wilson and Cobb, where the lawyer made disparaging remarks about a judge, again, what this court has said is, well, if the lawyer is an objective good faith basis for what they said, then that could be an affirmative defense. But the lawyer has that information. The lawyer knows, it's presumably what the basis for that accusation was. It's not a burden, it is not an undue burden to put on the lawyer the obligation to come forth with that information. By contrast, in a case like this, and I think it's important, and I want to respond to Judge George's comment or question to Attorney Harbison. Remember, in this case, the information didn't actually come from the client. In most cases regarding Rule 1.6 or Rule 1.9, the situation arises because the client says something to the lawyer, a marital infidelity, for example, that is confidential. The question isn't where did the information come from? The question is that information confidential? Is it generally known? If your client is a celebrity and the information of the infidelity is all over the internet and the newspaper, and it would not take much skill, knowledge, or effort in order to obtain that information, then the information is generally known and therefore not confidential. So,
may I ask you a question?
Sure.
I'm starting to see a difference between generally known and generally knowable. Do you see any traction there?
I think I would, Your Honor, and I think I would phrase it as the difference between available and accessible. And so, for example, yes, information, and I agree with Attorney Harbison that, with some effort, pretty much everything is available on the internet in this day and age. The question is whether it's accessible. The John Smith example, for example, of course, a common name may not be generally accessible. But remember that this respondent, and I'd found it by finding it on his local newspaper. We don't know whether he Googled it or whether he just was reading the newspaper and happened to see his client name show up. But that's immaterial. I think the key test ought to be, and this goes to, I know what Justice Lowy is most concerned about, is how do we distinguish between how much effort? And again, it shouldn't be up to the respondent, and it is not an undue burden to place on bar counsel the obligation to say, well, this information is not generally accessible or accessible, because it would require, let's say, for example, let's use an analog version, something from an old arrest record that somehow hadn't been digitized, and one would have to go to a library in a small town out of state and look on a microfiche in order to obtain that information. Well, if a lawyer discloses that, knowing that it's not on the internet, that the only way somebody would know about it would be to go to another state and look in the library on microfiche, then the lawyer runs the risk of that. But that's not the lawyer doesn't have the burden of disproving that. The burden should be on bar counsel because it has to prove that the information is not generally known.
Counsel, I need to go back to this because it's the problem that I'm still struggling with.
Sure.
You keep saying that there would be an undue burden on the respondent. I keep going back, and I read your brief, and I read that you think that Murray is inapposite to this case. I don't necessarily follow, because like in Murray, once again, before this respondent decided to file that pleading, there was some calculus that the lawyer had to make that it was okay for him to do this. So why is it, and I know you go through that, the procedural process, that there might be an order to show cause, or that you might have complaints and they've got to list why, all the reasons. But before we even get to that point, the lawyer's got to make a decision that it's okay for me to do this. And for all of the other exceptions that might be applicable, whether or not they thought that some third party might be harmed, or that they were in danger, that the lawyer has to make a decision that it's okay for me to make this disclosure. Why is it an undue burden to say you've got to demonstrate what your thinking was and that it falls within this exception?
Well, so Your Honor, it may or may not be an undue burden depending on the circumstances of each case. And I agree with you, and the board agrees with you, and the board agrees with bar counsel, that ethical practice requires that before a lawyer makes a disclosure, that lawyer needs to assure himself or herself that the information is not confidential. Totally agree with that. Remember, in this case, the lawyer read about it in the newspaper. So the lawyer at that point says, oh, this is in the Daily Patch in Marlborough, Massachusetts. I found my client's name simply by reading the newspaper online. The lawyer then says, well, since everybody else, my neighbors and my other community people, people in my community can read it as well, I don't think this is confidential. I found it just by opening up the newspaper online. Therefore, it's generally known. And therefore, and to your point, yes, it was a gratuitous filing in federal court. But remember, one of the reasons that lawyers have, one of the exceptions under Rule 1.6b, for which the lawyer would have a burden of proof, would be to defend themselves against allegations of malpractice or unethical conduct or some other allegation. We don't know, because bar counsel didn't call Mr. Brennan as a witness, but Mr. Brennan may have decided that his professional reputation depended on him making this what you would refer to as a gratuitous filing in federal court. So I think there are important public policy reasons why a lawyer may feel that they have to disclose this information. I agree with you. We agree with bar counsel that the lawyer has an ethical obligation to confirm for themselves that the information is not confidential. But that is a separate question from who has the burden of proof.
Not necessarily, because if all of that is true, what is so difficult about saying that once the lever is dropped and a complaint is filed against you, that you have to do all of these things in establishing your affirmative defense?
Sure. Well, and I think if I can, that allows me to jump to my third point, which is public policy. And I think what the board wants to emphasize here is the importance of the integrity of our process. Just as a lawyer should make sure that, or should ensure to themselves that the information that they are disclosing is in fact generally known or not confidential. It is incumbent upon bar counsel under our process to have a basis to make an allegation, to file a petition for discipline. And as we set forth in our brief, there's an adequate opportunity for bar counsel to investigate a respondent, take an examination under oath. Our rules of pleading require that the lawyer explain why they believe the information was not confidential, which the lawyer did in this case. And with that burden of production, if you will, if that modicum of information coming forward from the lawyer is provided under the text of the rule, and under general principles of fairness and due process, the burden should then be on bar counsel to say, well, no, you say that this information was not confidential, it was generally known, but we have satisfied our burden to show that it would actually take extra skill, knowledge, and effort in order to obtain that information. And that's where the burden should rest on bar counsel.